I remember the exact moment she entered my courtroom, because in all my years on the bench, in all the storms of arrogance and desperation that have swept through those oak-paneled walls, very few people have ever walked into my chamber with such deliberate contempt wrapped around them like perfume. The double doors opened with their usual restrained groan, but what stepped through them was anything but restrained. She came in draped in obscene wealth, a tailored ivory designer suit cut so sharply it looked sculpted rather than sewn, diamond studs burning beneath the fluorescent courtroom lights like cold sparks, her heels striking the marble floor in slow, insolent clicks that echoed louder than they should have, as if even sound itself had decided to make room for her vanity. I watched from my bench as she paused, not because she was uncertain, not because she respected procedure, but because she wanted every eye on her. She was young, perhaps 26, but there was an ancient entitlement in her expression, something inherited and polished over years of never hearing the word no. Her lips curved into a smile that never reached her eyes, and when the bailiff instructed her where to stand, she glanced at him as though he were a servant who had spoken out of turn. I have seen powerful men crumble under indictment. I have seen career criminals tremble before sentencing. But this woman, Cassandra Vale, daughter of billionaire magnate Raymond Vale, entered my courtroom as though she believed justice itself could be bought wholesale by her family's accountants. The gallery felt her before it understood her. There is a shift in atmosphere that happens when true arrogance enters a room built for accountability. People sit straighter. Silence hardens. Even the air changes weight. Cassandra approached the defendant's table without urgency, her attorney whispering frantically beside her, papers trembling in his hands as though he already understood what she did not. That this was not a boardroom, not a gala, not one of her father's penthouse dining halls where consequences could be dismissed with a signature and a wire transfer. She sat before being instructed to do so. That alone was enough to tighten something inside me. My courtroom runs on order, not ego. I let the silence lengthen before speaking, because silence, when properly used, is one of the sharpest tools a judge possesses. She noticed me then, really noticed me, and leaned back in her chair with an expression that bordered on amusement. Then she laughed, softly at first, then audibly when she saw my face. Not nervous laughter, not disbelief, mockery, pure mockery. In that instant, I felt the familiar rise of judicial anger, the kind that must never show itself in haste. I folded my hands atop the bench, studied her case file without speaking, and thought, "You have mistaken composure for weakness. That is a very expensive mistake." The file before me was thick, heavier than most felony packets, swollen with witness statements, forensic reports, financial analyses, traffic camera stills, sworn testimony, hospital documentation, and the kind of detail that tells a story long before a single lawyer opens his mouth. Cassandra Vale had not simply committed a crime. She had detonated herself through the life of another human being with such reckless indifference that the law itself seemed insulted by her behavior. The charge at the center was aggravated vehicular assault with malicious negligence, felony obstruction, intimidation of witnesses, destruction of evidence, and attempted coercion through financial influence. Yet the paper alone did not capture the true ugliness. I lifted the first photograph. A wrecked compact sedan crushed nearly flat against a concrete divider. Another photograph. Blood on shattered windshield glass. Another, a man in an ICU bed, face reconstructed by steel braces and surgical stitching. The victim's name was Daniel Mercer, a 48-year-old public school janitor, father of two, widower, night shift worker, a man whose entire annual income would not equal the cost of the bracelet Cassandra wore to arraignment. I remember looking at her as I turned those pages. She was filing her nails. The prosecution began slowly, carefully, as competent prosecutors do when they know outrage alone is not enough. They laid out the night in increments, and I listened as the timeline unfolded with sickening precision. Cassandra had left a private rooftop party in downtown Manhattan at 2:14 a.m., intoxicated beyond legal threshold, though her blood test had later been delayed due to interference initiated by private security staff loyal to her family. She had ignored her chauffeur, ignored her assistant, ignored the valet. Witnesses testified she laughed while taking the keys to her imported electric supercar, boasting she owned half the city anyway. 7 minutes later, driving at nearly triple the posted speed limit, she ran a red light and struck Daniel Mercer's vehicle broadside as he returned home from his second shift. The impact spun his car into a barrier hard enough to snap the frame in 2 places. And then, what I found hardest even after decades in law, she did not call emergency services. She stepped out, surveyed the wreckage, saw Daniel trapped and conscious, begging for help through blood and broken teeth, and instead called her father's legal fixer before she ever dialed 911. I watched Cassandra during this testimony. She yawned. Her attorney, Mr. Levinson, tried repeatedly to contain her, and I could see in the rigid line of his jaw that he knew he was representing a disaster wrapped in couture. When the prosecution introduced witness testimony from a paramedic who arrived first on scene, Cassandra interrupted aloud to say, "This is so exaggerated." Her lawyer touched her sleeve sharply, whispering, "Stop speaking." She rolled her eyes in my courtroom. The paramedic, voice steady but strained with remembered disgust, described finding Daniel Mercer slipping into shock, while Cassandra sat on a curb 50 feet away complaining that blood had splashed onto her shoes. Those words landed in the courtroom like stones in water, ripples of disbelief passing through every bench in the gallery. I watched one juror physically recoil. Another pressed her lips tight against tears. And still Cassandra remained untouched, chin tilted upward, fingers drumming a rhythm of boredom on polished wood. I have presided over murder trials where defendants displayed more humanity by accident than this woman displayed by choice. Then came the surveillance footage. I have learned never to underestimate the force of recorded truth. Human testimony can be challenged, motives questioned, memories blurred. Video is cruel in its clarity. On the courtroom monitor, the intersection appeared under sodium streetlights, time-stamped and merciless. Daniel's sedan entered lawfully. Cassandra's car entered like a missile. The collision erupted in sparks and shattered glass. Gasps rose from the gallery. But the worst part came afterward. The footage showed Cassandra stepping from her vehicle, steady enough to walk in heels, approaching Daniel's crushed driver's side door. The audio was faint, but enhanced forensic capture isolated her words. Daniel's voice, choking, pleading, "Please, help me, please." Cassandra's reply, "Don't die in my car's camera range." I felt my hands tighten against the bench. Even now, remembering it, I feel that same cold disbelief. Then she turned away, phone already at her ear, already protecting herself, while a man's life leaked onto asphalt behind her. The backstory widened in darker directions over the next hours. Detectives testified that by dawn, Cassandra's father's legal team had dispatched personnel to the crash site in an attempt to pressure city towing contractors into surrendering vehicle telemetry data before police retrieval. A security consultant offered cash to a traffic technician to misplace intersection recordings. One witness, a college student who had stopped to help Daniel, received anonymous threats warning him not to testify. Financial trails tied all of it back to shell accounts managed by Vail Holdings subsidiaries. The defense attempted distance, suggesting Cassandra had no knowledge of these actions, but then prosecutors introduced text messages extracted from her deleted phone backups. One message, sent at 3:02 a.m., "Make this janitor disappear from the story before Dad wakes up." Another, "If he dies, insurance handles it cleaner." In my years on the bench, there are moments when evil reveals itself not in violence, but in language stripped of conscience. Those messages were such moments. Cassandra smirked when they were read aloud, as though audacity itself were a shield. By the 8th day of proceedings, her entitlement had become almost theatrical in its brazenness. She interrupted witnesses to correct pronunciation of brand names. She complained the courtroom temperature was inhumane. She asked on record whether proceedings could be shortened because she had a resort reservation in St. Bart's. Once, during sidebar recess, I watched her lean toward her attorney and say too loudly, "Just tell them Daddy can rebuild the man a better car." That sentence hung in the room like poison gas. Mr. Levinson looked physically ill. I remember studying her face then, searching for any crack in the lacquered shell of narcissism, any flicker of shame, confusion, fear. There was none. only irritation that reality refused to conform to her expectations. I thought of every defendant I had sentenced who came from nothing and still understood remorse better than this heiress raised amid every advantage civilization could provide. When Cassandra finally testified against her counsel's desperate advice, the courtroom entered a silence so complete I could hear paper fibers shift beneath the clerk's hands. She took the stand with the confidence of someone accustomed to curated interviews and flattering magazine profiles, not cross-examination under oath. Her answers were polished until challenged, then sharp and petulant. She admitted driving, admitted drinking socially, admitted leaving Daniel trapped because, in her words, "I panicked and I'm not medically trained." But under prosecution pressure, the truth emerged in splinters. "Why didn't you call emergency services immediately?" she was asked. She shrugged. Then said the sentence that sealed her moral ruin before the court: "People like him sue people like us for sport." I heard someone in the gallery sob softly. I felt something in me harden beyond anger into certainty. Some defendants come before me broken by circumstance, some by addiction, poverty, trauma. Cassandra Vale had been broken by privilege. Then Daniel Mercer entered to give his victim impact testimony, and the emotional gravity of the courtroom changed entirely. He walked with a brace locked around his spine, one leg dragging half a second behind the other, each step a visible negotiation with pain. His face still bore the map of reconstruction surgeries, scars tracing silver lines from cheekbone to jaw. He carried no theatrics, no hatred, only exhaustion. When he sat, I saw his hands trembling over the prepared statement he could barely bring himself to read. His voice cracked on the first sentence. He described waking after 9 days in a coma to learn he would never again lift his youngest daughter without risking spinal collapse. He described losing his job because the school could not indefinitely hold a night custodian position. He described the mortgage default notices, the foreclosure threats, the humiliation of needing neighbors to bathe him after surgery. Cassandra stared at her phone until I ordered it confiscated. Daniel's daughter, Emily Mercer, was permitted to speak next, and though she was only 17, there was an old grief in her eyes that no child should carry. She described finding her father weeping in the kitchen because he could no longer button his own shirt without pain. She described dropping out of debate club to work evenings at a grocery store. She described hearing Cassandra's televised interview. Yes, Cassandra had given an interview during pre-trial release in which she called the incident a PR exaggeration, and watching her father turn off the television and sit in silence for 2 hours. I remember swallowing hard behind judicial composure, because judges are human before we are robes and gavels, and there are testimonies that cut through all legal abstraction and arrive directly in the conscience. Emily ended by saying, "She hit my father once with a car, but she keeps hitting us every day by acting like we're nothing." There was not a dry eye in the jury box. Medical experts followed, and with clinical precision, they translated suffering into numbers. Titanium rods implanted, 6 reconstructive surgeries, permanent nerve damage, lifetime pain management projections, estimated lost wages over 20 years, psychological trauma assessments documenting panic attacks triggered by engine sounds. But medicine cannot quantify dignity lost in fragments. Daniel described how he had once worked 16-hour days proudly, never asking for help, and now needed assistance climbing stairs. He spoke not with rage, but with a bewildered sadness that made his suffering heavier. "I keep asking myself," he said, eyes fixed not on Cassandra, but on the floor, "what kind of person sees another human being bleeding and thinks first about shoes?" I wrote that sentence in my notes, not for legal relevance, for memory. Because some questions deserve never to be forgotten. The defense attempted mitigation through character witnesses from Cassandra's social circle, philanthropic gala organizers, lifestyle consultants, family acquaintances speaking of her vibrant generosity. And the effort collapsed under its own absurdity. Their polished praise sounded grotesque against the raw human wreckage already established. Then prosecutors introduced evidence that while Daniel lay in rehabilitation, Cassandra had posted vacation photographs from Monaco captioned, "Surviving fake scandals with champagne." That image, projected in court, was perhaps more damning than any statute citation. Daniel bowed his head when it appeared. Emily covered her mouth. Cassandra, confronted, claimed the post was misinterpreted satire. I remember leaning back in my chair and thinking how rare it is to witness someone so committed to self-preservation that truth itself becomes beneath them. By the time closing arguments ended, I no longer felt anger in the ordinary sense. Anger is heat. What remained in me was colder, steadier, more dangerous. Judgment clarified by evidence beyond doubt. The jury deliberated less than 3 hours before returning guilty on every count. When the forepersons spoke the final verdict, Cassandra's face changed for the first time since arraignment. The arrogance did not vanish all at once, but it fractured. A small twitch in her jaw, a blink too rapid to conceal fear. Her father, seated behind counsel, gripped the bench so hard his knuckles blanched white. Yet even then, Cassandra tried one last defense against reality. She laughed again, softly, incredulously, and looked up at me as though expecting me to soften what the law required. That was when I knew sentencing would need to be more than punitive. It would need to speak for every citizen who has ever believed wealth places some lives above others. Sentencing day arrived beneath gray rain, and the courtroom was packed beyond capacity. Reporters lined walls, public benches overflowed. Cassandra entered in prison-neutral attire rather than couture, and the absence of luxury exposed how much of her identity had depended on armor made of labels and diamonds. When I began to speak, I did so slowly because words from the bench are not merely sound. They become record, precedent, moral declaration. I told her I had presided over thousands of cases, and that while the law measures acts, courts also confront character revealed under pressure. I recounted, point by point, her decisions: to drive intoxicated, to strike a man, to deny aid, to obstruct justice, to intimidate witnesses, to mock suffering, to weaponize privilege. I told her the court was not punishing wealth. It was punishing contempt for law, for life, for humanity. She began crying before I finished the second page. Then came the moment I had felt building since the first laugh she gave me. I looked directly into her tear-streaked face and said, "Miss Vale, your father's money built towers, bought influence, and insulated you from ordinary consequence. But this courtroom is the one place your surname arrives naked." She shook her head violently, whispering, "Please, no, please." Her attorney asked for leniency, citing youth and rehabilitation potential. I denied the request. My voice rose only once, but when it did, every person in that room felt it. "You left a man to die to protect your image." The words cracked through the chamber like a gavel strike from somewhere older than law. Cassandra collapsed into open sobbing. I imposed the maximum sentence allowable under statute: 18 years incarceration without parole eligibility before 12, full restitution, mandatory asset liquidation from her personal trust holdings toward Mercer family compensation, permanent revocation of driving privileges, and additional penalties for obstruction and witness tampering enhancements. The courtroom was utterly silent for 2 full seconds after I finished, as though reality itself required time to settle. Then Cassandra screamed, not cried, screamed. A raw animal sound of disbelief from someone encountering true consequence for the first time in her life. She turned toward her father, begging him to fix it. He did not move. For all his empire, he sat frozen before the one currency he could not spend. The bailiffs approached, and what followed remains one of the starkest images of my career. Cassandra clutched the defense table with manic desperation, her manicured fingers slipping against polished wood as officers pried them loose one by one. Her face, once so composed, had become streaked mascara and panic. "I'm sorry," she cried then, finally, but the courtroom knew what I knew. She was sorry for herself, not for Daniel Mercer, not for Emily, not for the wreckage she had authored. As they led her away in restraints, she twisted back toward me with hatred replacing fear, and I met her gaze without blinking. Some lessons arrived too late to save us from ourselves. Months later, Daniel Mercer returned to my courtroom for a restitution compliance hearing, and I barely recognized the quiet resilience in him as strength rather than injury. He still walked with pain, but there was steadiness now. The restitution funds had saved his home from foreclosure. Emily had returned to school. A community fund, inspired by public coverage of the case, had helped cover rehabilitation equipment insurance denied. Daniel thanked the court, though gratitude was never owed to justice for doing its duty. After the hearing, when the courtroom emptied, I remained alone on the bench for several minutes, listening to the hush that follows consequence. I thought about Cassandra in her prison cell, stripped at last of curated illusion. I thought about how many parents mistake indulgence for love and how often unchecked privilege becomes a weapon before anyone names it so. In the final accounting, this case was never truly about a billionaire's daughter, nor even about one catastrophic night at a red light. It was about the ancient and stubborn collision between arrogance and accountability. Money can purchase comfort, delay scrutiny, and distort access, but it cannot repeal moral gravity forever. In my courtroom, I have learned that character is revealed most clearly not by what people own, but by what they do, when they believe consequences belong only to others. Cassandra Vale laughed in the face of justice because she thought justice was a servant waiting for instruction. She learned too late what every citizen must eventually learn. When arrogance outruns conscience, the sentence begins long before the gavel falls, and the law remembers what pride always forgets. No fortune is large enough to bribe the truth. More than a year after I sentenced Cassandra Vale, I received the first prison conduct report submitted as part of her appellate review packet. And I remember sitting alone in chambers late that evening, long after the clerks had gone home and the courthouse lights had dimmed into that sterile midnight glow that makes every legal document feel heavier than it already is. The report described a woman who had entered state custody, still wearing the remnants of entitlement like invisible silk, demanding private accommodations, threatening wardens with family lawsuits, insisting that prison regulations were for ordinary inmates, and refusing meals because the food was, in her words, beneath human standards. I have read thousands of adjustment reports in my career, and they often reveal more truth about a defendant than courtroom testimony ever can, because prison strips away performance. There are no cameras there to flatter, no social circles to protect status, no father's attorneys hovering in tailored suits. There is only routine, consequence, and the slow erosion of illusion. Cassandra had spent her first 6 months in repeated disciplinary segregation for verbal abuse toward correctional staff, and yet what struck me most was a handwritten note appended by the prison psychologist. Subject demonstrates emerging signs of psychological destabilization when confronted with lack of control. I sat with that phrase for a long while. Lack of control. That had always been the true punishment awaiting her. Not merely confinement, but the collapse of a lifelong belief that she could bend reality to preference. In my courtroom, I had sentenced her body to prison, but prison itself had sentenced her ego to something far harsher: irrelevance. I later learned, through formal post-sentencing review and media filings, that Raymond Vale's empire had begun to fracture under the weight of the scandal he once believed he could contain. Investors fled quietly at first, then in waves, as leaked internal documents tied senior executives at Vale Holdings to witness intimidation schemes connected to Cassandra's crash. Federal regulators opened separate investigations into bribery channels uncovered during her criminal trial, and within months, the same man whose money once seemed to tower over every room found himself testifying before congressional committees with sweat on his brow and cameras recording every tremor in his voice. I watched portions of those hearings not with satisfaction, but with the sober recognition that corruption rarely travels alone. Wealth without ethics creates ecosystems of rot. Raymond Vale had not struck Daniel Mercer with a car, but he had built the fortress in which Cassandra's conscience was never required to develop. He had mistaken protection for parenting, indulgence for affection, immunity for success. I remember thinking, as I reviewed the related filings, that there are fathers who leave their children modest homes and honest names, and fathers who leave them private jets and moral ruin. Raymond had given his daughter every luxury except the one thing she needed most: the discipline to understand that other human beings are real. Daniel Mercer's recovery, meanwhile, advanced in slow, painful increments, and his resilience became, in many ways, the moral counterweight to Cassandra's collapse. At a civil enforcement hearing nearly 18 months after sentencing, he appeared again before me, stronger than before, no longer needing the full spinal brace that had once held his body upright, like scaffolding around a damaged building. His gait remained uneven, and pain still shadowed his expression in those brief moments when he rose too quickly or shifted in his chair. But there was something newly restored in him that no medical chart could quantify: dignity. He had used a portion of the restitution settlement not for extravagance, not even for comfort, but to open a small community maintenance business employing injured laborers who had lost previous jobs due to disability. I remember listening as he described hiring veterans with spinal trauma, warehouse workers with crushed knees, men whom the labor market had discarded because their bodies no longer matched corporate efficiency metrics. Daniel had transformed suffering into structure for others. That is a kind of justice courts cannot manufacture, but sometimes, if law does its part, can make space for. When he finished speaking, he thanked the court again, and I told him what I rarely say aloud from the bench. Mr. Mercer, what you built from pain honors this court more than any sentence I imposed.